Assalamu alaikum. This is Asif Ali Bhutto, and today I'm available with you all again with my podcast advocate Asif Ali Bhutto. And today I have taken a piece of learning from the Federal Law Journal, and that is the volume 2, issue 2, and March 24th, 2023, that is updated, and at serial number 8 we learn about the title, an overview of partition matters, author by Muhammad Masood Asgar, and would like to share about it, what the author has provided us and what learning we may get from this. Basically, at first point, the object preamble of the Punjab Partition of Immovable Property Act 2012 states that its purpose is to reform existing laws relating to partition and to provide for ancillary matters. Practice under the preceding enactment, the Partition Act 1893, had generated some difficulties and delays in finalization of partition matters, especially with regard to modes of partition. The Act of 2012 prescribed comprehensive procedure for partition suits, which was not the case with its predecessor. It made provision for frame of suit, prescribed time limit for filing written statement, gave panel provisions for curbing delays, and most importantly gave a mechanism of 3 clear-cut options for execution of preliminary partition decrees. The previous Act of 1893 had only a few provisions which related to modalities of sale of property in case partition was not done. Second point, legal aspects of a suit for partition. While dealing with partition matters, some key law points should be kept in mind. Partition is division of joint property among co-owners so that each may become exclusive owner of the part allotted to him. It converts joint enjoyment into enjoyment severally. A suit for partition may be brought by one or more of the owners of jointly owned immovable property, which is defined in Section 3 in C of the Act 2012 as a property owned jointly and not being an agricultural land. Unity of title and unity of possession is a condition precedent for partition suit. However, as a matter of legal fiction, every co-owner is presumed to be in possession of each and every inch of unpartitioned land according to his share, even though not in actual physical possession. A partition suit necessarily implies a prayer for declaration of joint ownership of parties. Co-owners seeking partition should be able to display clear title of property sought to be partitioned, and without title, all proceedings will be nullity. Sometimes partition is sought on the basis of PT1 form. It is settled law that PT1 form is not a title document and only a decree for protection of possession can be passed on the basis of it. As such, partition cannot be done on its basis. A suit for partition is based on old maxim of Roman law, nemo in communion potest invitus detenere, which means that no one can be kept in co-proprietorship against his will. This maxim is followed in nearly all modern legal systems. Partition is an equitable relief. A plaintiff cannot be allowed to pick and choose from joint property or properties. A suit for partial partition is bad in law and not maintainable. All co-owners of the joint property should be made parties to the partition suit and none should be left out in order to save the suit from plea of non-joinder. However, if some co-owner is not impleaded, proper course for court is not to dismiss the suit but implead the joint owner left out. However, a person holding only an agreement to sell in his favor from a co-owner is yet to become a joint owner and not a necessary party in partition suit. Every co-owner, whether arrayed as plaintiff or defendant, stands in the position of a plaintiff. If a co-plaintiff wants to withdraw from suit, he should rather be transposed as defendant so that suit does not become improper. Although Punjab Partition of Immovable Property Act 2012 is a special law, provisions of General Law Code of Civil Procedure 1908 are applicable given that they are not inconsistent with any provision of the Act of 2012. Third point, relevant provisions. While making a partition, these must be considered. Punjab Partition of Immovable Property Act 2012, Section 5475, Rule 13 and 14 of Order 26 and Rule 18 of Order 20 of Code of Civil Procedure 1908. Section 2 with Clause 15 read with Article 45 of Schedule of the Stamp Act 1899, Chapter 11 consisting of Section 135 to 150 of West Pakistan Land Revenue Act 1967 read with Chapter 18 of Land Records Manual and Chapter 13 of Land Administration Manual. Point 4. Preliminary matters. Jurisdiction. Partition of residential and commercial immovable property is done by civil court. Where is forum for partition of agricultural land is revenue officer. At times questions arise before court about jurisdiction for hearing and decision of partition suit where part of the joint property is residential or commercial on the one side and the other part consists of agricultural land. The point came up before Honorable Peshawar High Court in Rasham Khan versus Mirzat Khan 18, and the court held emphatically that only forum for partition of joint property consisting of land as well as constructed property is civil court. In similar case titled Qadir Ahmad versus Ijaz Ahmad 19, Honorable Lahore High Court ruled that where most of the joint properties were of residential commercial nature, civil court being the court of ultimate jurisdiction was the sole forum to decide the list. It further held that if from a cluster of joint properties one is within the jurisdiction of civil court, then it can also adjudicate upon properties not within the jurisdiction, being court of ultimate jurisdiction. For determining as to whether a property is agricultural or non-agricultural, regard may be had to following question: whether the land is occupied as the site of town or village, whether or not the land is assessed to land revenue, whether the land is being cultivated or not, whether there is construction over the land, if there is construction over the land, whether or not it is used for any purpose subservient to agriculture. Mere fact that some land was described as ghair mumkin does not necessarily mean that it has ceased to be an agricultural land. Jurisdi- juris- Jurisdictional competence of court is determined on the basis of value plaintiff share in the joint property. Limitation. Limitation for suit for partition is 6 years under Article 120 of the Limitation Act 1908, but it has been held that it is a continuing right and partition suit can be filed anytime during joint possession. Limitation is irrelevant and does not run in case of suit for partition. Procedure. Ordinarily, courts bifurcate a partition suit into two houses. First round ends on passing of a preliminary decree. A plan for a partition should state details of the joint property, implead all co-owners as parties. Relevant documents should be annexed, not more than 10 days notice instead of summons is to be issued to defendants. Defendant is required to file written statement within 30 days of his first appearance in court, failing which his defense shall be struck off. In case defense is struck off, defendant will not be allowed to lead any evidence. Court may order the owner in possession of property to deposit masonry profit in proportion to a share of a co-owner not in possession pending adjudication of suit, and in case of default, court may strike off his defense if he is defendant or dismiss the suit if he is plaintiff. Court can also pass order for masonry profits at final stage under section 12 of the Act. Decision of question of title and shares of joint owners amount to decree. For deciding question of title, court may and at times should frame issues and record evidence. Shares of co-owners can be amended later in case of death of an owner. Legal question about jurisdiction, partial partition, no co-ownership, non-joinders or misjoinders, and maintainability of the suit otherwise should be decided at this stage. Second round is usually known as final decree proceedings. After preliminary decree, three modes of execution are prescribed in the Act. These are appointment of referee,